For now, hi, my name is Lipika Devra. I am a Summit rep this year, a coordinator for the upcoming campaign season, and a coordinator for the philanthropy committee. I'm a rising senior in high school, and some of my interests include psychology, singing, and international relations. It is my pleasure to introduce you to our speaker today, Natalie Landau. Natalie is a third-year law student at American University, Washington College of Law at Washington, D.C. And she also works at the International Humanitarian Law team at the American Red Cross National Headquarters. Prior to this, Natalie received her bachelor's at the University of San Diego and worked at a public equities investment firm. Please feel free to use the Q&A or chat function to send in your questions if you have any specific questions during today's presentation. We will be monitoring that, and if possible, we will leave some questions to answer at the end. Without further ado, allow me to pass over to Natalie.
Wonderful. Thank you so much for that lovely introduction, Lipika. It's really great to have one of our incredible Youth Action Campaign advocates with us. So in today's discussion, I'll provide an overview of displacement occurring during times of armed conflict. Due to the time constraints, this is intended to build a foundation, not an in-depth analysis. But before we get into the substantive discussion, I wanted to first frame our perspective a bit. This is the Kutupalong refugee camp. It's located in Bangladesh and is the largest refugee camp in the world, with a population of more than 800,000 people in a 5-mile radius. Most of these refugees are Rohingya and have fled from ethnic and religious violence in neighboring Myanmar. The quotes seen here illustrates some of the hardships that displaced people face, whether it be the traumas they've experienced or the struggles they encounter after having fled. I won't read them out, but I do suggest that you pick one and read it for yourself. With them, displaced people carry horrific stories of brutality and little else. They've been forced to abandon their homes and sometimes their loved ones, endure a perilous and often violent journey, pay exorbitant prices to get a standing position on a decrepit boat or an overpacked truck, and all with the hope that they'll make it across the border and be received by that next country. But if they are lucky enough to make it, if their boat doesn't capsize, if they're not subject to human trafficking, their journey doesn't end there. They must then make the difficult adjustment to a new life in a country and culture they're not familiar with. While the movement of civilians and sometimes entire communities is nothing new, war has a tendency to speed this up. For this reason, displacement is often considered part and parcel of armed conflict. Essentially, where there is violence or the threat of violence, there is often displacement. Based on figures provided by the United Nations High Commissioner for Refugees and the Internal Displacement Monitoring Center, at the end of 2022, there were more than 108 million people forcibly displaced worldwide. Of that number, more than half were internally displaced. It's important to note that these statistics offer us a general guide for understanding the scale of the problem, but often displaced people are living in the shadows and are not accounted for. So as such, it's impossible to truly get an accurate number, so we can assume that these figures are in fact much higher. Merely the threat of violence is enough to cause displacement during armed conflict. But displacement is in fact often the result of violations of international law, or more specifically in this context, violations of international humanitarian law and fundamental human rights. As you can see here on the slide, these are some of the violations of international humanitarian law that lead to displacement. I won't read all of these violations out, but to highlight just a few, indiscriminate attacks, targeting of civilians and civilian objects, especially those essential to human survival, the use of civilians as human shields, and the denial of relief supplies and healthcare are just a few reasons that may cause people to flee. These experiences can take a toll, a significant toll, on displaced persons. Physical violence is often experienced both during the journey and at displacement and refugee camps. And as people flee, they may not have access to medical care, shelter, running water, and food. These deprivations can lead to living in unsanitary conditions, contracting diseases, and malnourishment. Other consequences include a lack of financial stability, independence, and access to education, which can have lasting effects. The loss of homes and communities, along with the exposure to extreme violence can also be detrimental to psychological well-being. Vulnerable groups, including women, children, the elderly, and the disabled, are at particular risk when displaced. Displacement may also be permanent. The end of war does not necessarily permit displaced persons to return to their homes. Destruction of infrastructure, explosive remnants, and general safety in the area all contribute to whether people will return home. In addition to the severe physical and mental impact that displacement has on those fleeing, these massive and sudden flows of migration have serious and long-term effects on state and regional stability, from a strain on local resources and resentment to increased tensions, food shortages, and economic instability. Accordingly, it is crucial that the international community work to meet the needs of displaced populations and host states, as well as address the root causes of displacement. But displacement comes in many forms, and the protection of displaced people varies greatly under international law. So before we get into the specific types of displaced persons, let's first establish some of the legal protections afforded to them under international law. First, let's take a look at international humanitarian law, or IHL, also known as the law of armed conflict. During times of war, states and warring parties are obligated to abide by the laws enumerated in the 4 Geneva Conventions, the additional protocols, and customary IHL. The protections set forth under IHL are applicable when a conflict meets the criteria for an international armed conflict, also referred to as an IAC, or a non-international armed conflict, NIAC. International armed conflicts are primarily governed by Additional Protocol 1, while non-international armed conflicts are guided by Additional Protocol 2. And although NIACs are more common, the law offers greater protections to civilians when there is an IAC. These legal instruments provide specific protections for civilians during conflict, including those displaced by conflict. As previously mentioned, violations of these protections are often what lead to displacement. For instance, Articles 54 and 14 of Additional Protocol 1 and 2, respectively, both prohibit starvation of civilians as a method of warfare. In addition to these broader civilian protections, there are also several provisions under IHL that explicitly prohibit forcible deportations and establish particular protection for refugees. As you can see on the slide, these are the relevant articles depending on the nature of the conflict. For example, Article 49 of the 4th Geneva Convention prohibits individual or mass forcible transfers and deportations. Evacuations of an area are permitted if there is a security risk to the population or an imperative military reason. And Article 147 includes unlawful deportation or transfer as a grave breach of IHL. There are also a few customary international humanitarian law rules, as articulated by the ICRC, that pertain to displacement and the protection of displaced persons. These are rules 129 to 133. As an example, Rule 131 requires that all possible measures be taken to provide satisfactory living conditions for displaced civilians, and including families not being separated. And Rule 132 establishes the right for displaced civilians to safely return home. Apart from these more general protections, IHL doesn't impose highly particularized obligations on states regarding displaced persons. This is where more narrow bodies of law come into play, like the Convention relating to the status of refugees. This treaty is not only applicable to states taking part in a conflict, but also to states that may be on the receiving end of refugee inflows. Additionally, treaties like this apply both in times of war and times of peace. When the Convention was adopted more than 70 years ago, along with the 1967 Additional Protocol, it was the most comprehensive codification of international rights offered to refugees. Today, there are more than 149 states that are a party to either or both the 1951 Convention and the 1967 Protocol. It's provided lasting contributions to the field, including a universal definition of the term refugee and the development of core principles like non-refoulement, which is explicitly espoused in Article 33 and holds that no state can expel or return a refugee to a territory where their life or freedom would be threatened. I won't go into detail on this, but it is important to note that this concept of non-refoulement is actually connected to concepts in IHL, which protect people from being transferred to countries where they will be persecuted. With that being said, just as the causes of displacement have evolved over the past few decades, so too have the needs of refugees. Accordingly, regional agreements like the OAU Convention, a treaty that's been ratified by 46 African countries, have been created to supplement the Refugee Convention. Additionally, the African Union's Kampala Convention, ratified by 30 African countries, is the only legally binding treaty that addresses the issue of internally displaced persons. And while these aforementioned instruments are binding on state parties, there are also agreements and principles that add to the existing framework. The Cartagena Declaration is one such example. Although not binding, it has been incorporated into the national laws and state practices of 14 countries in Latin America. And aside from the Kampala Convention, the only other instrument that deals with IDPs is the Guiding Principles on Internal Displacement. Again, this is not binding, but it is based on binding provisions of international law and holds considerable authority. The UN General Assembly recognizes it as a foundation for IDP protection and encourages states and relevant organizations to use the principles in situations of internal displacement. Even if states don't follow the guiding principles, they are still bound by international human rights law, IHL, customary international law, and any relevant domestic laws. So now that we have some understanding of that legal framework, let's unpack some of the terminology. Most of us are probably familiar with the terms refugee, asylum seeker, migrant, and maybe even IDP. But do we really understand the difference between these titles? And ultimately, why does it matter? First, some definitions. A refugee is a person that has crossed an international border and is at risk or has been a victim of persecution in their country of origin. Refugees have usually fled because these risks were so great that they felt they had no other choice. In its definition, the Refugee Convention implies that the following conditions must be met to qualify as a refugee. First, the person must be outside their home country. Second, they must have a well-founded fear of persecution for reasons of race, religion, nationality, membership of a particular social group, or political opinion. And third, either their own government is unable or unwilling to protect them from those dangers, or owing to such a fear, they are unwilling to return to their home country. An asylum seeker is very similar to a refugee in that they've also fled their homes due to persecution or human rights violations. However, they have applied for asylum and are seeking the right to be legally recognized and protected as a refugee in a specific country. For this, they must demonstrate that they meet the criteria mentioned previously, namely that there is a well-founded fear of persecution in their country of origin. An internally displaced person is someone who has been forced to flee their home, often due to armed conflict, persecution, or natural disasters, but who has not crossed an internationally recognized border. And finally, a migrant is a broader term used to describe a person who has left their country for a variety of reasons, maybe to seek safety or better prospects. While the term often refers to those who have left voluntarily, it's important to note that migration can also be involuntary. As an example, those fleeing climate change-related issues like drought. Legally, migrants are not refugees or asylum seekers because they do not meet the criteria for either term and likely do not face an impediment in returning home. So, why do these definitions matter? Well, these titles carry with them varying degrees of support. As such, obtaining a specific status is crucial as it determines the rights, protections, and treatment that individuals receive from the international community and from their own state. The laws I referenced previously show that some displaced persons have more rights than others, specifically refugees. However, obtaining refugee status is no easy feat. In fact, if you take a look at the Refugee Convention's definition of a refugee, as seen here on the slide, people fleeing general violence from conflict would not meet the criteria as they do not fall into one of these 5 protected groups: race, religion, nationality, membership of a particular social group, or political opinion. With that being said, the UNHCR has articulated that refugee status can be recognized through a prima facie approach, meaning it can be granted on the basis of readily apparent objective circumstances in the country of origin. Additionally, many countries and regions have expanded their definition to include those fleeing generalized violence, massive violations of human rights, or foreign aggression. As previously mentioned, the OAU Convention and the Cartagena Declaration have done just this. But it's important to remember that the burden of proof falls on the individual, and meeting these standards can be difficult due to a lack of evidence. If asylum is not granted and refugee status is not met, it doesn't mean that the individual is completely out of luck. They may be able to appeal the decision, and many countries will grant temporary protection to migrants whose home countries are considered unsafe. They're not considered lawful permanent residents or citizens, but are permitted the right to live and work in the receiving country for a temporary period of time. For example, in March of 2022, the European Union voted to grant temporary protection to Ukrainians fleeing the war. These measures can help to alleviate the burdens placed on national asylum systems when there is a sudden and massive inflow of migrants due to natural disasters or conflicts. A person's temporary status can be extended, but once it does expire, individuals will no longer have that protection and may revert to undocumented status, which means they are at risk of deportation. For internally displaced persons, unfortunately, the responsibility for their protection and meeting their basic needs lies with the state or authorities controlling the territory they're in. I say unfortunately here because states affected by conflict are often not equipped to meet these obligations. Additionally, if state forces are responsible for the persecution that caused the displacement, then the state is unlikely to make any effort to meet these obligations. These protections are governed by general international law and any conventions the state is a party to. If a state is not a party to a treaty like the Kampala Convention, then it has very few specific obligations towards IDPs. As previously mentioned, a significant burden is placed on receiving countries, including responsibilities and obligations towards displaced persons. Not only must states provide refuge, but they must also ensure protection of and provide basic necessities to those seeking safety within their territory. I'm only talking about the legal obligations that states have here, and not the political and social interests that may also be at play in meeting these obligations. The principle of non-refoulement is one of the core obligations that states have towards refugees, meaning that if refugee status is met, then a person cannot be sent back to their country of origin. The convention, along with IHL and regional treaties, provide additional responsibilities, including the access to courts and administrative assistance to obtain identity papers and transfer assets. However, the protection of rights and provision of basic needs and services are primarily guaranteed under human rights law. Something that recently dominated the news was the boat that capsized off the coast of Greece last month on June 14th. The fishing boat was being used to smuggle migrants into Europe, and it's estimated that there were somewhere between 400 and 750 people on board. Only 104 people were rescued and 82 bodies recovered, leaving hundreds missing and presumed dead. Many of the passengers were fleeing conflict and violence in their countries of origin, from Syria to Afghanistan. Shortly after the news broke, reports emerged that the Greek Coast Guard had been alerted to the boat in distress the previous day. According to Greek authorities, assistance had been offered but turned down. So, what legal obligations did Greece have to rescue and protect these passengers? Well, the primary law functioning in this situation is actually maritime and international human rights law. So under these frameworks, the boat would likely be considered within Greece's effective control, which would oblige them to provide immediate assistance and launch an urgent search and rescue operation. But more important to today's discussion is that this incident highlights the risks associated with displacement. Tragedies like this have become increasingly more common over the past decade. And according to the International Organization for Migration, since 2014, more than 27,000 migrants have died or disappeared in the Mediterranean Sea. Almost 2,000 migrants have died this year alone. Despite these sobering statistics, the number of migrants attempting to make this dangerous crossing is only increasing. And this illustrates how desperate certain groups are to flee and the dangers that they're willing to accept. Organizations like the International Committee of the Red Cross and national societies have long been at the forefront of providing vital assistance and protection to persons displaced by conflict and disaster. These groups, along with other non-governmental organizations, work tirelessly to ensure the well-being and protection of rights for displaced persons. The ICRC and the International Federation of Red Cross and Red Crescent Societies provide crucial assistance to displaced persons in a wide range of areas, including providing access to essential services such as healthcare, clean water, sanitation, food, shelter, and general security. The ICRC also assists in providing access to additional services, including psychological, legal, and financial. One particular area of focus is the reunification of families. During armed conflicts, families are often torn apart, with loved ones being separated due to the chaos and displacement. The ICRC's Central Tracing Agency Bureau and the Restoring Family Links program play a critical role in reuniting families and offering support. The CTA Bureau uses a comprehensive system of collecting and documenting information, including names, photographs, and other identifying details to facilitate the search process. This is also accomplished by coordinating with National Red Cross and Red Crescent societies that form the RFL, as well as other humanitarian organizations. Today, there are hundreds of case managers, data analysts, forensic specialists, psychologists, and lawyers working with the CTA to search for missing people and reconnect separated families across the world. Syria is just one example of where this work is being done. Often referred to as the guardian of the Geneva Conventions, the ICRC was the first organization to formally declare the violence as a civil war in 2012, imposing obligations under IHL on all parties to the conflict. The conflict has long been one of the largest displacement crises in the world, only recently having been surpassed by the conflict in Ukraine. It has resulted in more than 7 million IDPs and more than 5 million refugees. Due to the ICRC's principles of neutrality and impartiality, it was one of the few international organizations granted access into Syria at the start of the conflict. For this reason, the ICRC, along with the Syrian Arab Red Crescent Society and societies in neighboring countries, have provided much needed assistance throughout the conflict. In addition to the aid provided, it has registered tens of thousands of requests to help find missing people, help reconnect families with their loved ones, or find answers for them. Before we close, I would like to end on a more personal story that showcases the impact that humanitarian organizations can have. In June of 2014, militants invaded Gwaza, a town located in the northeast of Nigeria. The armed group proceeded to massacre hundreds of civilians, which led to hundreds more fleeing the region. Saleh is one of these displaced persons. He worked as a grain trader, but now lives with his family in an IDP settlement. With the support of humanitarian organizations and as a part of the ICRC's livelihood program, Saleh received a business grant that has allowed him to return to farming. This assistance may not address the physical and emotional struggles that he has endured, but it has alleviated some of the burden and has allowed him to support his family. So this brings me to the end of today's presentation. And as a final remark, I'd like to emphasize that IHL violations are one of the primary reasons for displacement during armed conflict. And displacement is often cyclical in nature, meaning that it can sometimes be a contributing factor to the onset of conflict. For this reason, it's really crucial that IHL be adhered to so that displacement and the continuation of conflict can be mitigated. But with that being said, I think we have some time to answer any questions that may have come in. And also to my incredible IHL team that's with me on the call today, please feel free to jump in at any point, but I will pass it back to you, Lapika, to open things up. Thanks so much.
Thank you so much for that informative presentation, Natalie. To start off the Q&A, we have a couple of questions. first question that many of the audience members may have is, what happens if a state is not a party to the Refugee Convention?
Yeah, so as I mentioned, there are a few relevant international legal instruments that protect displaced persons. Those arriving at the borders of a state that may not have ratified some of these agreements are still entitled to seek asylum as per Article 14 of the Universal Declaration of Human Rights, but they're not necessarily granted that asylum and not entitled to be granted that asylum. They're protected by the customary obligation of non-refoulement in international human rights law and other relevant human rights law provisions. But additionally, something to note is that just because a state isn't a party to any international treaty doesn't mean that they don't have their own refugee policy or as a part of domestic legislation or practice. So Bangladesh is actually a really great example of this. It's not a party to the Refugee Convention or to the protocol, but it's one of the top refugee hosting countries in the world.
Thank you so much for that clarification. Next, can you tell us a little bit about how asylum seekers prove persecution?
Yeah, so as I discussed, the burden of proof falls on the individual. A lot of the times it is context specific, and many countries will have their own, unique criteria. But oftentimes the proof of persecution is supported through personal statements, doctor reports, news articles, reports from human rights organizations, affidavits from witnesses, photographs, videos, and of course, the proof of membership in a particular social group. So generally, the hardest part of the process is establishing that connection between being a member of one of these protected groups and the persecution itself. So as an example, say you're a member of a political party and you're facing violence in your home country. To obtain refugee status, you must be able to provide evidence that the violence directed towards you is because of the fact that you support this political party and not because the country that you're living in just has a really high crime rate. So this procedure is definitely easier for some rather than others, but that has a lot to do with access to evidence.
Wonderful. Now let's move on to some audience questions. Laura asked, do women constitute a particular social group under non-refoulement law?
Yeah, that's actually a really great question, Laura. It's interesting to note that we don't have gender as one of those protected groups, but the UNHCR defines particular social group as a group of people who share some immutable, unchangeable characteristic which distinguishes them from society at large. So some bodies support including women and some don't. So it's that very legal answer of it depends, because states can choose to interpret this, this sort of characteristic, this particular social group in their own way.
Wonderful. Matthew asked, which international body is in charge of governing and enforcing IHL during conflict?
Yeah, that's a great question. So for IHL in particular, it's, basically any state can choose to investigate and prosecute war crimes. But in some circumstances, this is done by international and regional courts. So you have the ICC, the International Criminal Court, the tribunals, if any exist in a particular conflict, but also domestic court systems under universal jurisdiction. And the Security Council can also compel states to comply with their obligations or establish a tribunal to investigate breaches.
Thank you for that. Another question that we have is, in your personal opinion, is the current legal framework fully equipped to deal with the ever increasing numbers of displaced persons across the globe?
Yeah, I think that's a really, really interesting question. And I'm sure we all have a lot of thoughts on that. The legitimacy of any real law, it really just depends on our acceptance of it and our willingness to be bound by it. But, just because there is a violation of a treaty, it doesn't necessarily mean that a treaty is failing. So it's easy to look at failures and situations where countries haven't honored their obligations, but there are actually a lot of examples where these obligations are being met. They just don't catch the headlines. And I think it's really important to remember that we have lived in a society where these obligations weren't being met because they hadn't been codified into law. And it was measurably worse then. But that's not to say that we can't keep improving. And, as sort of these challenges evolve over time, as the causes for displacement change, for example, climate change, I think so too should the law. And that's one of the great things about international law, is that it is an ever evolving legal framework. But hopefully that answered that question.
It sure did. I think that is all the questions that we have for today. Yeah, well, this brings us to the end of today's session. Oh, I think someone is raising.
Oh. Yeah, feel free to yeah. Yes, payment.
My question is, since the start of the Afghan civil war, Iran has systematically committed violation of such laws, but the world has responded with a blind eye. As an Afghan, I probably know this, and then probably the rest of the world knows this, that during 1980s, Iran committed genocide of killing 20,000 Afghans, and they decided to build a road on it to hide the bodies. But the world did not respond did not take a firm action to stop such violations. So what would be your take on that? Would there be hope in the future, or it will still be the same?
Yeah, I think thank you so much, Payman. It's a very, poignant question. I think there's always that hope that the legal framework will, address and acknowledge victims of international law violations. I think it's very similar in that, from my previous answer, in that you do see, places where the framework isn't working, or you see places where states are not meeting their obligations, their duties under international law. And that's something that can always be improved on. And my hope is that for the future, we can get better mechanisms, we can set up better, enforcement structures to address these needs. But I think it's a really wonderful question, and I thank you for highlighting that.
I think that's it for the questions. But yeah, well, this brings us to the end of today's session. Thank you so much for joining, and we hope you have a good day.
Yeah, thank you so much, everyone. It was wonderful to be here with you all, and really appreciate it. Thank you.